Hello, everyone. Welcome to our webinar on intellectual property hot topics for in-house counsel and business leaders. And thank you for joining us. I'm Panayota Daphniotis, partner and national lead for our IP group in Canada. My practice focuses on all areas of intellectual property, and I will be your moderator today, as well as a speaker for this session. Now, I guess to begin, as many of you know, April 26th, and every April 26th, is World Intellectual Property Day. And it's a great day to learn and promote the role of intellectual property rights in encouraging innovation and creativity. This year's theme for World Intellectual Property Day is Women and IP, Accelerating Innovation and Creativity. And I would encourage each of you to take a look at the World Intellectual Property Office website with great information about the importance of IP and world IP events that are going on everywhere in the world, such as ours here today, but as well as to take a look at some of the inventors, the women creators, the women entrepreneurs around the world that are being recognized this year with the theme of World IP Day. So today I'm joined by some amazing members of our intellectual property team from across Canada and the United States, which you can see on the screen right now, which I have the great pleasure of working closely with on a regular basis. These are seasoned experts and tremendous collaborators, and I would really encourage you to take a look at their bios to get to know them a little bit better. And so to introduce them, we have Matthew Diskin, a partner in Toronto, Richard Johnson, a partner in Vancouver, Chris Celius, partner in Edmonton, Kevin Greenleaf, counsel, Silicon Valley, Jennifer McKay, counsel in Ottawa, and Bob Tarantino, counsel in Toronto. Today, the topics that we will cover will be, we'll kick it off with a discussion on generative AI. We'll move over to a litigation theme discussion, coordinating cross-border IP litigation in the United States and Canada. Then we will move over to notable developments in Canadian trademark law in Canada. And we'll close it off with a discussion on patents versus industrial design. What are the differences and what are the benefits of each? And so I think with that, we will move right into the first topic of today's discussion, which I have the pleasure of doing with my colleague, Bob Tarantino. So to begin the discussion on generative AI, I think I'll just sort of lay the foundation, maybe some groundwork on the intersection between AI and intellectual property, and really just in particular copyright. So it always makes sense to start with the what. So what is copyright? We know that copyright is the exclusive right to produce, to reproduce, to publish a work, or to perform it, to perform an original literary, artistic, dramatic, or musical work. And among the rights that copyright protection provides is the sole right to make reproductions of the work and or to authorize someone else to do it. And that's a point that is really going to come up again and again through our discussion here today. And then the other right that I'll address is just the moral rights, which protect the integrity of the work and the identification of its creator. Now, it's worthwhile to sort of start with mention and a reminder that just because something is posted and publicly available on the internet, it does not mean that it is that you are able to freely use it. Those are very different things. Now, the terms and conditions of a website where you might find content would state what use is permitted. And we know that in most cases, that permission, that right to use that is granted by those terms and conditions is limited, and it's limited to personal and non-commercial use. So it's really important to recognize that available does not mean permission to use. So with that in mind, who owns copyright in a work? it's worth mentioning as well that with all the different forms of intellectual property, there are different mechanisms for the ownership of IP when it is created. So I'm not going to get into patents, trademarks, and industrial design. I'm just focused on copyright, but I do want to flag that when it comes to copyright, it is the author, the creator, I would say, that is the first owner. If a work was created within the course of employment, the ownership may reside with the employer. I'm not getting into the specifics of this. I think Bob may get into this in a little more detail, but the term, the course of employment, does have a specific meaning under the law and is often debated. So we should just be aware that the mechanism of ownership for copyright can be different than other forms of IP. So if we keep in mind, who the owner of the copyright is, and what the right of that owner is under copyright law, i.e. the sole right to make reproductions of the work and to authorize others to do it, let's pivot over into the IP implications for our AI systems. So what is protected? What is infringed? Now, we know that AI systems have the potential to really revolutionize a number of industries. But this technology does raise some complex IP issues. And Canadian law is still undecided on many of those sort of copyright law related issues that will apply to AI systems. And that does make it, in my view, it does make it challenging for companies to really properly weigh the risk and opportunity of an AI system for their organization. Common sort of elements are data inputs and data outputs that fall into this, risk and opportunity discussion and analysis. And I'm going to sort of refer to those sort of data inputs and data outputs in a moment. But I do want to highlight some of the main issues to be discussed. And the first basket of issues, I would say, relate to infringement of existing rights. So if we think about the use of the data that to train an AI system, and the potential for AI generated content to infringe on existing IP rights, that's sort of the first basket of concern or issue that comes up in talking about an AI system. So we know that text or data or an image can be considered a copyrighted work. We're not getting into what will attract copyright protection. That's a robust discussion in itself that I'm not going to cover. But if an AI system generates a piece of text or an image that resembles a copyrighted work, the owner of the original work may have grounds for a claim of copyright infringement. And this isn't a theoretical risk. We know that this is happening here and now. We have already seen litigation commence in the United States on this exact point, where you have artists that are claiming in a lawsuit against, let's say, Stability AI or other creators of AI art generators. And they're alleging that these organizations have infringed the rights of millions of artists by training their AI tools on billions of images that are being scraped from the web without the consent of the original artist, without the consent of the owners of the copyright. Basket number two in terms of the challenges are who owns the rights to the content that is generated by the by the AI, excuse me. So under current AI laws, it's really unclear who is the creator. If you remember, I mentioned, who's the owner of the copyrighted work? Who is the creator? Who's the owner? Is it the AI, the creator of the algorithm, the owner of the computer that ran the algorithm? Is it the owner of the source of the data that was trained to train the AI, etc.? So if we think about these issues, these challenges, and these concepts, and I sort of break it down into, the AI system itself, we'll sort of connect the dots, I think. And so to start, I would say very generally that an AI system, just in my words, would be sort of software plus infrastructure plus data. And the very first step, which is the really key step in setting up an AI system, would be the collection of data. So a company would go out there and to create an AI system, collect lots and lots of data. And these large data sets are obtained by, data mining and web scraping, which basically includes, extracting various forms of data from many, many different sources that exist. Including the internet, of course. So the main copyright issue that may arise, as I touched on earlier, is that these data inputs can result from copyrighted data being used to train the AI program. And we see that, companies are constantly looking for do's and don'ts that they need to be mindful of when they're collecting data. And that's really important if you're trying to avoid this risk. But practically speaking, how challenging is it to actually check and see if the data that you're collecting is protected, and if the source of the data allows you to use it for the purposes for which you're collecting it. And there is currently an absence of a clear rule in Canada for machine learning, and this is what we often refer to as a text and data mining exception. So that's a really important data collection first step. Then second step is you assign value to the data. That's called labeling. We're not really going to talk about that too much, but then we get into the training process, incredibly important part of the process. So much computing power occurs in this step, and so much expertise in terms of training is required. And the last step, again, I'm keeping this very, very simple, is the AI software generates output, it's put into production, the company monitors it to make sure it's doing what it's supposed to be doing. This is the data output part of the process that I mentioned earlier. And so the question there is the AI generated content infringing on existing rights, and who owns it? Now, I'm not getting into in this discussion how to establish infringement by an AI generated work or an AI assisted work, only to highlight that to do that, for that kind of assessment, you need some transparency in the AI application. What is the source of the training data sets? There's a significant amount of verification involved, and we know that AI applications and systems are these proprietary black boxes. So it's really hard they're closed off from public inspection. So it's really hard to get at that kind of information. So in short, there are many unanswered questions in Canada when it comes to copyrighted works and the training of AI systems. And I think with that, I'll hand it over to Bob for sort of part two of this discussion.
Great. Thanks, Peniana, and thanks to all the attendees for joining the fun today. Peggy, if you want to move to the next slide. What I'm going to do is, in my portion of this discussion, I'm going to try and sort of lean into the ambiguities that Peniana has highlighted and hopefully leave you with some lenses or frameworks or tips or potentially tricks to kind of navigate your way through this environment. And in order to make that productive, let's just level set and talk about what AI is. So as Peniana mentioned, it's a software platform, usually, that you interact with. And I think that's something that we need to highlight here. And I'm speaking to an audience, I'm presuming here, that consists of entities or organizations that have employees, and there's a potential that those employees or other representatives of the organization will be using AI. And I want to focus on that interface there, because it's people have to interact with AI. They have to give information to AI. They have to prompt the AI in order to generate a response or generate content. That content often takes the form of images or text, and it uses existing data in order to generate that new content. And I put quotes around new because there's a potential risk here, as Peniana has alluded to, that the content actually isn't new or that it's infringing the underlying data in some way. Generative AI has a ton of applications. People are using it for all kinds of exciting things, even just in the last like 6 to 8 weeks. The nature of use and the types of things that people are doing has changed dramatically. So this is a tough area to speak on about definitively because it's evolving so rapidly. One of the things which makes AI really interesting and fun for people is that it creates content that is basically indistinguishable from human generated content. And people can use it to automate tasks that they are otherwise required to do in the course of their jobs. We're going to focus on those two things in the remainder of this discussion. Peggy, can we move to the next slide, please? So there's a bunch of output risks. Which range from, the complete fabrication of data, often referred to as a hallucination. The data or the output could be inaccurate in the sense that it's outdated because it's trained or it's generated using data which is old. Garbage in, garbage out. The AI systems only have access to limited sets of data normally. Those data may be old. They may generate a response or an answer which, works for, let's say, Canada, but doesn't work in the United States, or is correct for Canada, but not correct in the United States, or is correct in Ontario, but not correct in Quebec. And so you have to be sensitive to these frailties in the outputs, right? You pose a question, you get an answer which sounds definitive, but you need to understand, the user need to understand the context in order to make the assessment of whether it is in fact useful. And as we've already talked about in a couple of different ways, the content itself can be infringing. So the new content which is created can consist of a substantial part of the existing content, thereby giving rise to a potential copyright infringement claim. And we also have to be sensitive to the potential for bias or discrimination in the output or in the manipulation of the data. As Panayota mentioned, these AI systems are black boxes. So we don't really know in most cases how the data is being manipulated or how the outputs are being generated. Peggy, next slide. I found this on the internet thanks to a gentleman named Alexander Tukhanov. I think this summarizes everything you could ever possibly want to know about the question of, should I use ChatGPT? Do you need the output to be true? If the answer is no, knock yourself out. Use ChatGPT. If you need it to be true, you have to undertake and implement a process which is going to help you validate whether it is in fact true or not. So bear that in mind as you use ChatGPT. Next slide. Focusing on this issue of the inputs, you have to prompt ChatGPT and other AI system, generative AI systems. Keep in mind that employees, people generally, might have a tendency to input confidential or sensitive information into the AI in order to get a response. As it says on the slide, professional services firms have ethical duties to maintain client confidences, but that duty or that obligation or that norm of maintaining client confidences applies well beyond professional services firms. So make sure that you are sensitive to the fact that your employees may be putting data into the system which you don't want them to be putting into, and which could pose real risks or jeopardize your competitive position if that material is out there. That's potentially a problem if people are putting in sensitive or confidential data into the system, because the AI systems often have the ability and the right under their terms of use to make whatever use of the data that they want to. So check those terms of use. ChatGPT ends up sucking up a lot of the oxygen, and keep in mind there are lots and lots and lots of different generative AI platforms out there. And so you have to make sure in using any single one of them that you are assessing that particular system with reference to its terms of use and what it is that it is allowing you to do. And I hope on the next 2 slides to give you some illustrations, which will hopefully maybe not put the fear of God into you, but at least make you sensitive to the concerns here. So next slide, please, Peggy. This is taken from a ChatGPT FAQ. And I've highlighted in the red box there, when you use our consumer services, ChatGPT or DALL-E, which is an art generating system, we may use the data you provide to us to improve our models. You have to proactively opt out of the sharing of your data. If you look at the answers to the FAQs, you'll see that there's a relatively broad disclosure entitlement on their behalf. They can use the systems internally. Some other some other generative AI systems in their terms of use allow them to share the information with third parties. Next slide, please. These are not theoretical concerns. In this news report, this is more than 7 days ago now, Samsung workers had input proprietary, confidential source code into ChatGPT and asked it to improve the source code. So that source code is now out there in the wild. That should be a problem for anybody who's thinking about it. Next slide. Penny also already mentioned a lot of the issues pertaining to copyright. So I'm not going to go into this in too much detail other than to reflag it. Note that there are lawsuits which are already being launched. The danger for you as an employer is that you get caught in the blowback or get caught as a defendant in a lawsuit because one of your employees has prompted an AI system to create content. That content is viewed as infringing, and then you use that content in some fashion, which puts you on the radar screen of the rights owner. So imagine, for example, you have a marketing campaign that you're creating, your employees ask an AI system to generate some visual images. They generate the visual images, they get put into commercials, they get put into online ads, they get put into other materials which are disseminated. Content owner looks at it and says, hey, that looks an awful lot like the picture I originally created or the photograph I took, and they start a lawsuit. That's what you need to be concerned about. Next slide. There are also these very technical issues pertaining to authorship and ownership, which at the moment we just don't have answers to. And so I don't want to delve into those too much, but what I do want to flag is you have to contend with the fact that the stuff that an AI system creates, its output, may simply not be owned. So if your employees are using AI to create content, which you are then exploiting, bear in mind the fact that you may not own that content either. Right? You as the employer, which means that the public, that anybody else, competitors, can themselves use that content and you won't have a copyright infringement claim against them. Keep in mind or assess whether that is something that you need to be concerned about. Next slide. Pulling the lens back a little bit from what are strictly IP issues, I want to talk about what I've called ethical issues. I'm not sure that that's the right term, but you have to think, I think organizations have to think about how they handle or how they approach the use of AI, generative AI systems by their employees. Do you care whether your employees are using AI to create content? Right? In some contexts, that's a really meaningful question. Right? So, in academic contexts, if students are using generative AI to create essays or test answers, that can be a real issue for a variety of ethical and normative reasons. You have to query whether you want your employees or whether you care about your employees using these same tools to create content in the course of their jobs, right? Is it a negative thing if somebody hands in work which they themselves haven't really created or have created in a manner which has been assisted by generative AI? Those are questions. I'm not proposing an answer to that. I'm not saying it's good or it's bad. I think you have to answer that question in your context. As I alluded to before, what happens if AI spits out content which it has already created for somebody else? Do you need the content to be unique to you? And what about your customers? What about your other stakeholders? Do you need to disclose to them that you're using AI? Right? Does that matter to them? Do they want to know whether you're using it or not? Let's move to the final slide and I'll wrap up with some final points to take home. I think I've said this a couple of times. I'm going to say it again. Think about it. think about how you should use AI, whether you should use AI in your particular context, and have a policy. Read those terms of use. Don't just at a minimum, absolutely do not just let your employees make use of generative AI in the course of carrying out their work. Understand what it is that is happening with the data, what kind of liability you're exposing yourself to, what kind of indemnities you're entitled to under the terms of use of the particular services that are being used, and tailor your policy to that. Maybe there are some systems that should be used or acceptable, others cannot be used. If you do need to use AI, consider bespoke contracting with the providers of the services, right? These are all consumer-facing businesses. Many of them are open to creating tailored products which serve a particular end user. Talked about considering how AI factors into performance assessment. Make sure you have that policy. Make sure people are properly trained if they are allowed to use AI, and make sure that both at an organizational and an individual level, you're aware of the potential risks. So train to avoid inadvertent and damaging disclosure, train to spot potential infringement, train to identify errors in the output if it matters whether the content is true or not, and train to know when not to use it, when you just simply should not be using generative AI in the course of creating content, in the course of carrying out your business. I'm done. I will turn it over to the next panel featuring Matt, Chris, and Kevin. Thanks, everyone.
Thanks, Bob. Super interesting discussion. Kevin, Matt, and I are here to speak to a topic that I know is near and dear to our three hearts, and hopefully near and dear to the hearts of many of our viewers and listeners today, coordinating cross-border litigation in Canada and the US. So to quickly set the stage, I'm speaking the obvious here, but the Canadian and US economies are intimately intertwined. Many companies doing business in both jurisdictions, and therefore often having IP rights applicable in both countries. So it's incredibly common that when you have an IP infringement or enforcement issue, it's happening in both countries at once. And there are some key differences and similarities in the US and Canadian legal systems that lead to some interesting strategic issues and decisions to be made in terms of where you sue and how such actions are pursued. So that's what we'll be dealing with at a high level in our discussion today. And just to kick it off, I think one of the main points of distinction to be drawn with respect to the Canadian system is that it's, generally speaking, significantly less complex than the US in terms of court structure and available forums in which to resolve disputes. For various reasons, the vast majority of IP disputes are dealt with in our federal court in Canada. And that is also generally the case in the US. But the federal court in Canada is significantly simpler than its equivalent in the US. The Canadian federal court is a single court, a unitary court, with one set of binding legal precedents from one federal court of appeal. In contrast, in the US, you've got 94, Kevin will correct me if I'm wrong about that number, I believe 94 district courts, which are the federal level trial courts, each of which is governed by one of the 13 different circuit courts, with each effectively being its own court of appeal. And each of those circuit courts can take and have taken, in some instances, some very different approaches on the same or very similar legal issue. So one example that I could speak to is I understand in the US, there's in US trademark litigation, there's a doctrine that is applied by some circuit courts, but not by others, which is this idea of initial interest confusion. And so it lets you establish, if that doctrine applies, it lets you establish trademark infringement if consumers are briefly confused between brands upon a first glance, even if they're not ultimately confused when they're making their purchases. So that's just an example. There's many others, but the result being that depending on the issues you're facing in a case, it could very well be advantageous to sue in a given circuit in the US as opposed to another. And another way of putting it is that you're far more likely to end up potentially with forum shopping concerns in the US. You know, which court is the best one? Which court will best deal with your issues in a way that suits your client's interests, your company's interests? Whereas in Canada, you've just got the one federal court of appeals setting the ground rules and precedents for the federal court level generally.
Well,
So that's
just briefly, Chris, if I could add just a
yeah, absolutely.
small comment there. And in Canada, because of the way our system works up here, you've got this problem about if you get an injunction federally, of course, you can enforce it everywhere in Canada versus an injunction in a specific province. And I think that's an important consideration that we're often looking at, as to what's the if the nature of an infringement or the bad guy is very much constrained to one province, you may want to be constraining your litigation to that province for tactical or cost reasons, or even sort of, let's just say, juridical reasons. And I know that can be slightly different as well from the states. So sorry to interrupt you, Chris, but I think that's that national scope. It's weird because our constitutional courts are the superior courts, which are the provincial courts, but the federal court actually has this ability to give national injunction.
Yeah, no, that's a great point, Matt. Never hesitate to interrupt me. And you know what, you never have, so I take no offense. Yeah, Kevin, how does that compare in the US in terms of court structure and where you might think about suing?
Well, thanks, Chris. I think you generally got it correct. I think you're more of a trademark guy, but you do patents too. But I'm more of a patent guy who tries to dabble in trademarks from time to time. And with the patents system, we have the Court of Appeals for the Federal Circuit, which handles all patent appeals because they wanted to get rid of that problem of jurisdictional splits on issues. And so that did a pretty good job of it, but you can still get splits within the district court level. And that's true in trademarks as well. So even within a circuit, you may have two different district courts that handle issues differently. And we see that a lot too. So forum shopping is an issue, both in the US and Canada. I was on a case recently where, we had a trade secret issue that was handled differently in Canada than the US. It can be important to say, well, what's the trade secret law in Canada versus the U.S. and how will it play? How will that handle? Be treated in either place? So where would be our best place to sue? So you can do forum shopping internationally too. I mean, we frequently look at Germany as a litigation to sue, and now we get the Unified Patent Court in Europe. So Europe is going to be, people predict anyway, a much hotter area for patent litigation. So there's a lot of international strategies you can do as well, because you don't want to sue companies globally in every jurisdiction. That would just be cost prohibitive. So you pick a couple, try it out, ones that'll be favorable to you, and go there. Costs in the US, everybody knows about that, and the discovery, et cetera. But in the US, we also have what we call Article 3 courts under the executive branch. We have the Patent Trial and Appeal Board at the United States Patent and Trademark Office, and where I have a lot of experience working. Also, the International Trade Commission, where I also have experience. The International Trade Commission allows you to get an injunction for importation of goods into the US, and that's being more frequently used by foreign entities. If you have a US patent, you can prevent other foreign entities from importing into the US. So we've had a number of cases like that, particularly from China. A Chinese company owns a patent, they want to stop their competitors from importing, and they file a complaint in the International Trade Commission. Then finally, we have the Court of Federal Claims, which is, you use that to sue the US government. So I don't know, Chris or Matt, did you want to add some more before we move on?
No. Let's keep it rolling. There's so many topics. We could talk for hours. So, Chris, whenever you want to pick up next on the discussion. I mean, from my perspective, I would just say, because I do a lot of entertainment, copyright related matters, one of the key things that everyone really needs to focus on is what are the contractual boundaries, around these claims? Because the problem with copyright often is that it's a territorial matter generally. Your copyright exists under the Berne Convention. It doesn't really matter where you made it as long as you're in a contracting country to that convention, which most civilized nations are. And so then the question simply becomes, if I want to bring a claim, yeah, okay, I have rights. May have originated this copyright in Canada or wherever. But why would I pick Canada or the US or the UK or how do I pick my jurisdiction to sue on a copyright claim? And, to be honest, the most important point really starts with, especially again, in these kind of entertainment properties, it's like, is there any kind of contract that binds someone to a jurisdiction? Because if I can get that, then I could be looking at a broader scope of damages outside of a certain country. If it's a third-party infringer without a relationship, then I've got to be a little bit more tactical about where are their assets, where can I hurt them, where can I get them to stop? If it's a company that happens to be a Canadian company that's perhaps infringing copyright in the United States for their activities, is there a means that I can get to them in Canada, perhaps using an economic tort? For example, not necessarily limiting myself purely to the territorial copyright regimes that do apply, because countries can only make rules about what happens in their own country. So I can't necessarily sue for U.S. copyright in Canada. I really can't, right? But if it's a Canadian company and I'm a Canadian generator and they're exploiting my work in the US, maybe I've got an economic tort claim, for example. So you've got to be very thoughtful about that when you get into the hardcore copyright stuff. But I say, every analysis needs to start with contracts, but I'd be interested in both your comments on that.
I completely agree. I mean, I've been involved in cases where, it's a dispute, a trademark dispute between, let's say, a distributor and the actual IP owner. And in some cases, you do actually have an arbitration clause that specifies, you're not supposed to go to court. And so you can get into these sort of thorny fights. Sometimes a party will say, I really want to be in federal court because the federal court is the exclusive jurisdiction where you can invalidate a patent or a trademark registration. You might say that's where I would really want to go. But if you've got that binding arbitration clause, if it's properly drafted, and that can be a point of contention as well, sometimes it's sort of a false start. You definitely have to pay very close attention to those sorts of provisions right at the outset before deciding where to sue.
Well, and at the outset when you negotiate these deals too, right?
Yeah, absolutely.
And as to where you want to have injunctive relief rights and under what law will apply, because you'd agree to say that Canadian law may apply, but it's a U.S. court, and that, so you can start kind of sometimes have to think about the horse and the cart order.
Yeah, and another issue particular to U.S. cases, if you're going to have an arbitration clause in your agreement, which I don't generally favor. I mean, it's just kind of the Wild West, and it doesn't really save you a lot of money. Is whether you're allowed to go to the Patent Trial and Appeal Board, for example. There's been some case law recently that did not really seem all that appropriate. So that might be something you want to determine in advance, just to be clear on that point, because it's a much more efficient venue for invalidating a patent with experts, patent attorneys with technical degrees, versus a jury who may not really understand what you're talking about.
And you can't relitigate that in the States, can you? If the PTAB, like if they make a ruling, is that something that gets reviewed at a federal court level, or
Yeah, it gets reviewed at the federal circuit. And
but on an
it's appeals.
appellate jurisdiction rather than a rehearing? Is that right?
Well, you can do both, but yeah. They have various rules where they will defer to the board in certain instances and review other things de novo. So are you done, Matt? Okay, so I just wanted to go over quickly a couple of points on efficient patent litigation. I said I'm a bit of an expert at the Patent Trial and Appeal Board, and it's a good way to get out of district court. If you move quickly, you can hopefully get a stay of your district court litigation, stop the costs, and then if you win, then your case is over. If you lose, you may face some estoppel, but you may have some admissions from the patent owner that will get you some good non-infringement arguments. So, and there's also inter-party or ex-parte re-exam now. That's much cheaper. So when I'm advising clients, I give them a whole bunch of options and the pros and cons of each of them. I personally like ex-parte re-exam. It's a lot cheaper. Maybe 10% of the cost of an IPR, but it's a higher risk of losing. But you can file multiple serial re-examinations that kind of ameliorate that problem. So, I think, and it's constantly changing. So if you're going to file an IPR, make sure that you get counsel who knows what they're doing. There's constantly new rules, constantly new decisions. It's a really fast-paced area of the law that you need an expert to deal with. A lot of people get into it, they don't really know what they're doing, and it's kind of painful to work with those types of people. But I hope this was helpful. So Chris?
Yeah, I thought I'd quickly touch base on one point on trademark litigation between US and Canada that I think is of interest. It might flip the forum shopping discussion a little bit on its head and touch on some other points we've raised. And it really relates to, the first question I typically get from clients where, you've got a potential trademark infringer or copycat out there, other than, how much is it going to cost to deal with this? Really the concern is how long is it going to take? What can we do right off the hop to try and stop things in their tracks, act aggressively? And of course, one great way to get the other side's attention is to apply some immediate pressure through an interlocutory or preliminary injunction application to get the defendant, force them to stop any infringing or allegedly infringing activity pending trial. And if you can get that kind of order early on, it's not unusual for the defendant then to come to the table for some very serious settlement discussions because you've already got a significant win under your belt. They'll be faced with a decision of, well, I've got to stop. Does that mean I've got to I effectively have to rebrand pending trial if they want to continue selling the good or service in question? And so this is a common strategy, obviously, in both US and Canadian litigation, but I think there's a significant difference in likelihood of success depending on which court you're in and which jurisdiction you're in. There's, of course, one of the main blockades or prongs or requirements for getting that kind of relief is showing irreparable harm that can't be compensated for in damages. And I understand until fairly recently in the US, there was a split again in case law precedent in terms of that test. And I understand some circuits they'd employ a presumption. If they felt that consumers were likely to be confused, they would presume irreparable harm, obviously making it a lot easier to overcome that hurdle, whereas other circuits refuse to apply that rule. So of course you'd have some incentive there for that whole forum shopping concern. I understand that all changed in late 2020 with passage of the Trademark Modernization Act. That presumption of irreparable harm now actually applies countrywide. And so that makes it, in my view, quite an attractive form overall US federally to try. If you want to get that injunction early on, that makes it a lot easier. Unfortunately, in Canada, the state of the law at the federal court level makes it quite difficult still to get that sort of injunction. Since 1994, the Center Ice case issued by our Federal Court of Appeal held that you need clear and non-speculative evidence that irreparable harm will occur through the trademark infringement continuing if you don't get your immediate order. And since that time, there's a few exceptions, but the floodgates have not opened. That case law is still good, making it very difficult to get that kind of order. So there is, and I think this goes to a point you made earlier, Matt, about the you can sue in both federal court or superior courts provincially. And oddly enough, in the provinces, it's generally been my experience, it is easier to get that interlocutory injunction than it is in the federal court. Like there's Court of Appeal precedent from the provinces, some of the provinces that say you don't have to show there will be irreparable harm. You have to show some sort of meaningful risk. There's cases in my home province of Alberta sort of suggesting that if it's going to be hard to show causation, show that the infringement's causing
show
harm,
that the quantum of damages is going to be determinable, even could be enough. I mean, the Sheehan and Rosie cases, BC's got even a slightly lower standard, but then you got to really think through that. Where do you want that order enforceable? Do you need it nationally? You got to make that tough risk. And then the last thing, I'm sorry, Craig, I know we're probably over time. Really quickly, remember in Canada, you have adverse cost awards against you if you lose. In the States, unless you've got maybe like a Section 11 or federal court rule situation where it's like really ill-founded kind of case, you don't so much have that risk. And that can be a big material factor, the adverse cost risks that are sort of presumptive in Canada. But I'm sure we are hitting our time. I'm sorry, but we should shut up.
No, you're probably right. I've been keeping track here as well. So I guess we'll just take the metaphorical baton at this point and pass it back over to Panayoda and to Jennifer McCabe for a discussion on trademark law.
Great. Thank you. Thank you so much for that. So Jennifer and I are going to dive into a discussion on trademarks, and the points we will cover off today really all highlight the importance of protecting your trademarks and why trademarks are important to your business. And we know that, trademarks make it easy for your customers to find you, and the marketplace is crowded. It's hard to distinguish your business from your competitors sometimes, but trademarks and brands help customers immediately know who they're dealing with. They help recognize reputation based on a brand, and we know that brand is a critical factor in driving customers' purchase decisions. Trademarks also allow you to effectively utilize the internet, effectively utilize social media, and your brand is the first thing that customers are going to put into a search engine or a social media platform when they are looking for your products and services. And protecting your trademark to avoid use by your competitors of your mark in search engine optimization can have important advantages. And we're not getting into search engine optimization discussion today, but it is something not to overlook. And finally, remembering that trademarks, like all other areas of IP, are assets of a company. It's important to flag that trademarks as an asset of your company never expires as long as you continue to use them and renew them. And so that is also a key element to keep in mind. So I think with that, maybe a good place to start would be to highlight some, just take a minute to highlight some very high level trends with trademarks in Canada. And Jennifer, maybe you can talk to us a little bit about that, about what you're seeing.
Well, Panayoda, thank you. One of the biggest issues in the trademark landscape these days is the fact that we are currently experiencing the repercussions of Canada's new trademark legislation, which came into effect in 2019. Our Trademarks Act was substantially revamped for the first time in more than 60 years. While many of the legislative updates were required in order to bring Canada's trademark law into the 21st century, one of the big consequences is that Canada now has a huge backlog of trademark applications awaiting examination, and it's taking around 4 years for an application to be examined subsequent to the filing date. So as you noted, trademarks can be good indeterminately, which is an amazing thing, but the tricky part now is getting that initial registration. It can be a very long process. So if 4 years seems like an extraordinarily long time, it absolutely is. And to put it in context, in the US, an application is examined approximately 8 to 10 months after filing. In the EU, an application is normally examined in about a month, and a UK application is examined in a few weeks. So the Canadian Trademarks Office is diligently trying to reduce the backlog, but it will likely be a long time before we see significant improvements. And just to tie it all together, they are using AI to help speed things along. So I think that should I think they'll start using more AI, and hopefully that will work so that you'll be able to get a Canadian trademark registration in a reasonable amount of time. Excuse me. So the tremendous backlog of applications awaiting examination can be attributed to three main factors. Possibly the most significant change to our trademark legislation was to dispense with the requirement to state that a mark is in use in Canada, or anywhere else in the world for that matter, in order to obtain a Canadian trademark registration. That was somewhat controversial, but it is where we are today. So applicants who do not have short-term plans to use a trademark in Canada, or even medium or long-term plans for that matter, can still file applications and obtain a registration. Secondly, it's now possible to designate Canada as an extension of an international trademark registration, and that has led to a significant increase in the number of international applicants checking the Canada box on their international registration. Thirdly, the increase actually started prior to the coming into force of the new legislation, as it made classification of goods and services mandatory, and we now have additional fees for any classes after the first. So while prior to 2019, the government fee was a flat $250, great bang for your buck, no matter how many goods and services you had in the application. The maximum government fee for an application filed today is, get this, $4,978.79, so almost $5,000. So it went, I mean, granted, it's somewhat rare that an applicant has all 45 classes of goods and services in their application, but that's a significant difference. All that to say, there was a bit of a run on multi-class trademark applications prior to 2019 to take advantage of the low filing fee. So currently we're in a situation where it takes about 5 years for the average trademark application to proceed to registration. There are a couple of ways to accelerate applications, and one is by selecting all of your goods and services from the pre-approved examples in the Goods and Services Manual. Unfortunately, that is not possible in all cases, but if it is possible, it's certainly a no-brainer to do it. But the Goods and Services Manual is necessarily finite, and there are, of course, millions of goods and services in the world that cannot fit within the pre-approved examples in the Goods and Services Manual. So if you can do it, it's highly recommended, but in many cases, it's not possible. The other way to speed up your trademark application is to request expedited examination, which requires the filing of an affidavit setting out exceptional circumstances. And there are 4 circumstances which may result in you getting expedited prosecution. Number 1 is that a registration is required for enforcement purposes. Number 2, a registration is required to stop counterfeit products from entering Canada at the border. Number 3, a registration is required to prevent trademark rights from being severely disadvantaged in online marketplaces. And number 4 is to perfect a foreign registration for the same mark. An expedited prosecution, if granted, is actually a wonderful thing because it can go from your application taking 4 years to get examined to potentially being examined in a couple of months. But the Trademarks Office is quite strict, and you absolutely have to fall within those 4 categories. Sorry, Paniota?
No, go ahead, sure.
Okay. Yeah. Another aspect that is a relatively hot topic at the moment is the ability for Canadian nationals to file international applications via the World Intellectual Property Office, or WIPO. For trademark owners who want to register in multiple jurisdictions, this can streamline prosecution, renewals, title updates, as there is a single point of contact, which is amazing as opposed to dealing with agents in every jurisdiction, and everything can be done in English and or French, which is also really helpful for Canadian applicants. It can also result in significant cost savings if a trademark owner intends to file in generally more than 3 jurisdictions. Filing via WIPO is not foolproof, however, as if the Canadian application or registration on which the international application is based fails for some reason within 5 years, then your designated countries have to be converted into national applications, which can result in additional expense. There's also the fact that Canada is probably, in my opinion, the most demanding trademarks office in the world when it comes to goods and services descriptions. They have to be described extremely specifically, and your international registrations in each jurisdiction you have to use the same goods and services that you've used in Canada, which limits it, because in some jurisdictions you can get away with very broad descriptions of goods and services, but if you're based on a Canadian application, then you're restricted to the goods and services of the Canadian application. And last but certainly not least, as far as trademarks office matters go, is the fact that Canadian trademark examiners can now object to trademark applications on the basis that the mark is not inherently distinctive. And that has resulted in initially they cast a very wide net with that objection, and it is definitely slowing down prosecution because there are so many applications that are encountering that objection. So all that to say, the takeaway is that trademark registrations are taking a very long time, especially in Canada, and you should start the process early if you need a registration, and you'll be in a much better place. So,
yeah. And we'll be reinforcing that message in terms of that. So recap, longer delay, greater complexity in drafting and filing and prosecuting the trademark applications, and higher costs over the last few years. So, so if we just sort of move away from that just for a moment, I think it's worthwhile to highlight a couple of the key cases that have come up over the course of the last year. And maybe I'll ask you, Jennifer, just to highlight one case that you think is worthwhile to point to in terms of how it's shaping Canadian trademark law in Canada.
Sure, Panetto. How about one issue as opposed to one case? Because
Sure.
bad faith is a new ground to invalidate trademark registrations that was put into our act in 2019. And we didn't have anything to really assess how that was going to be applied until 2022. But now there were 3 cases decided over the last couple of years. And I don't know if you want me to get into the details, but basically in each case, a third party registered a trademark that originally belonged to another entity. The first case was, it was a Chinese restaurant that was quite popular in that jurisdiction. Somebody registered it in Canada and then demanded $1.5 million from the Chinese company to transfer the registration. They said, no, thank you, that was too expensive. So then they tried to sell it online. Anyway, in that case, the court held that the registration should be canceled on the basis of bad faith. There's also the Alliance Auto Glass case where a US company was licensing Canadian companies to use the trademark, and one of the sub-licensees in Canada went ahead and registered the trademark in its own name. In that case, the court canceled the registration as well. And then the most recent case is Chung's Bakery versus Easy Win, where it was a Chinese bakery out west, and they had registered a bunch of trademarks. The parties had been in conflict over their trademarks, I think in 2015. So Easy Win should have known that the marks were considered confusing and that they were not entitled to register those trademarks. So in that case as well, the federal court canceled the trademark registrations on the basis of inter alia bad faith. So we have 3 cases where bad faith was brought into play over the last year or so, and I'm sure we're going to be seeing lots more of those.
Yeah. Well, one case that I would want to briefly highlight is a question that touches on, to register or not to register. And I think this particular case, the principles are really simple, but I almost think it's textbook in underscoring the advantages of securing trademark rights through registration for the goods and services with which it's associated, but also the importance of conducting a trademark search prior to selecting and commencing use of a mark in Canada, because it can really identify some potential issues down the road that a company would want to avoid. So in this particular case, just really quick without getting into all of the facts, it was a well-known restaurant in Yorkville, Ontario, opened in the late 90s, called Sassafras, and that's a Z at the end of that mark. Well known in Canada, a lot of press coverage in Canada and outside, and they eventually got a registration for the mark maybe 10 or so years later. At some point, that trademark owner found out about another restaurant in Ontario that in 2020 that was using Sassafras with an S at the end. And probably some demand letters were exchanged. That third party refused to stop using the mark, and court proceedings were initiated where the trademark owner of the Sassafras, Z on the mark, alleged infringement of its trademark and depreciation of goodwill. So the interesting part, no surprise, the court found that there was really a high degree of resemblance. What they looked at was appearance, they looked at sound, they looked at the ideas that were evoked. The difference of one letter did not make a difference, and that's a common question that we get from clients when there's a really minor difference. Is that enough? And it often is not, to materially reduce the resemblance of the mark and the potential for confusion. So they also found that Sassafras with a Z was actually found to be distinctive because of all the sort of the promotion and recognition across Canada and outside. And so aside from getting a registration, which is a great thing for the Sassafras owner, they also noted that that mark had been in use for many years, longer than the third party mark with an S. There was, importantly, there was overlap between the goods and services, and you really do need that in this kind of analysis. So the Sassafras mark with an S on the end was confusing. The court found that it was confusing with the Sassafras trademark. So a good reminder on why it's important to search and why it's important to register. But if I sort of keep the theme of the importance of registration and switch gears a little bit, I think it's worthwhile in a discussion like we're having here, Jennifer, today, to talk a little bit about a development in Canada, Bill 96. And I think many of the attendees will have heard a fair bit about Bill 96 because there is a lot of discussion ongoing. Now, Bill 96, we know that in May of 2022, the Quebec provincial government adopted Bill 96, which includes some really important changes to laws that govern the use of English language in Quebec. Now, currently, so the current state in Quebec is if you have what's considered to be a recognized trademark, you've probably seen that wording time and time again with Bill 96 discussions, you benefit from certain exemptions from translation. But a recognized trademark in the current state is a trademark that's either registered, that's pending at the Canadian IP office, or where you have some common law trademark rights. And if you do have that recognized trademark, you are exempt from translation requirements when you're displaying that mark, as long as there's not a French version of the mark that is registered in Canada. But the changes that are going to be coming into effect with Bill 96 narrow that exemption for recognized trademarks. And it's only a registered trademark that benefits from that exemption. Now, additionally, so even if you have a registered trademark, and we're really just touching on Bill 96 here at a high level, there are many layers to pull back on Bill 96, but if you do have a registered trademark, you still have to take a look at whether or not there are generic or descriptive terms in your trademark that may be captured by translation requirements of Bill 96. And so in those circumstances, the trademark cannot be used alone without translation. Also to flag is that currently there's a standard of there needs to be a sufficient presence of French on commercial advertising, public signs, product packaging, labeling, etc. Whereas Bill 96 changes that to a markedly predominant presence of French, and that would be the new standard. So what do trademark owners need to know? They need to know, and Jennifer, you touched on this at length in terms of the delay that we have at the Trademarks Office in Canada right now, given that Bill 96 is coming into effect June 1st, 2025. If you have a trademark that is either never been filed for or that has been filed but is still pending, you will have some issues if you intend to continue to use it in English or in any language that's not in French. So we really strongly recommend that trademark owners, if you have not done so yet, that you take a look at your trademark portfolio to understand and identify which marks in your portfolio may be impacted by these changes. If you have a trademark application that hasn't been moved to examination, there are things that we can do that you alluded to, Jennifer, to expedite the examination of that mark so that it can have the hope of reaching a register status before June 1st, 2025. If you haven't filed a trademark application, you need to do so very, very quickly, like now. And you do need to look at your marks as a whole, whether or not they've been filed for or registered, to understand whether the additional translation requirements around generic or descriptive elements of your mark are impacted, and whether or not you will need to translate as well. So those additional requirements are coming into effect very quickly, and you do need to take action on those. And so I think we are at time on that. And so I think with that, we'll sort of close off the trademark discussion and pivot over to Richard, who will be talking to us about patents versus industrial design. Over to you, Richard.
Panayoda, sorry if I can just interrupt with one question.
Sure,
we do have a
course.
question, and somebody's wondering if there are updates on when the updated regulations will come out, and I think they're talking about the Bill C-96. I'm not aware of that. I think there are a lot of nuances though in Bill C-96, and we're waiting for different guidance on various points, right? But do you know anything about the updated regulations?
Sure. Yeah. Well, yeah. And we are continuing to await further guidance on Bill 96. There was guidance that we were expecting in January and then in February. And so I think it is coming, but it is coming slowly. So I think more to come on that, but the updates on the updated regs have not been made available yet.
Okay, thank you.
Thanks. And we will, just as a reminder to everyone, we will open up the Q&A at the end of the session as well. Thanks. Over to you, Richard.
Thanks, Panayoda. So yeah, in the 10 minutes or so that I have allotted here, I'm going to go over everything that there is to know about patents and designs. Just kidding, of course. This is meant to be a high-level overview of these other two types of intellectual property that are maybe less common than trademarks and copyrights, but are also very important, particularly for companies making and selling new products and services. So copyright is, maybe you've heard, copyright is an original, like you create original work, you automatically are protected by copyright. Trademarks, if you start using a new brand, you get some common law rights towards that. And you can register that, of course, but there is no equivalent for patents or designs, at least in Canada, for these sort of unregistered rights. If we could just go to the next slide, Peggy, thank you. So, at a basic level, and I want to just hit on this point because it comes up all the time. Patents and designs are different things. They protect different aspects of a product. I think the confusion often arises because in the United States, they're treated under the same statute, and they call what we would call an industrial design a design patent. But it is a very different type of protection than a utility patent, or as just what we would call just a patent. So a patent protects how things work. The definition in the Canadian legislation release is a new and useful art, process, machine, manufacture, or composition of matter. And the key there is it's got to be like new and it's got to be useful. So it's got to, it's how it works. In contrast, does an industrial design or design patent that protects how something looks. So if you've got the product that works the same way as existing products, but it looks different, then that might be something that is protectable by a design. In Canada, for example, the definitions, features of shape, configuration, pattern, or ornament, or any combination of those that appeal solely to the eye. And I skipped over a bit there because it also has to be applied to a finished article. So a design for just like an abstract pattern is not something you can register. You have to like say what the pattern is on. So that's the sort of basic distinction between what a patent covers and what a design or design patent covers. For patents, if you want, you need to apply in each country you want to be able to enforce your patent rights in. If you get a Canadian patent, that will do you no good in the United States, and vice versa. If you want to be able to stop someone from using your invention in Canada, you need a Canadian patent. Or if you want to stop someone in Japan from using your patent invention, you need a Japanese patent. Designs are similar, although I should add that some countries do provide a sort of shorter term protection for unregistered designs. I mean, I'm thinking primarily of the EU. There's unregistered design. Like if you come up with a new design product, I believe you get 3 years under the current EU rules to stop others from directly copying you. And some national laws will provide for protection of original sort of designs applied to articles without separate registration. That's not possible in Canada, at least. Ordinarily, if you come up with a piece of art and you use so let's say you design a really beautiful chair and you want to, that's your chair sculpture, you can put it in a museum and you just make that one sculpture. Like you'd have copyright on that in theory, assuming it's original and it's on criteria. But if you take that same chair design and start selling it to people, there's this little provision in the Canadian Copyright Act says, well, then it's not copyright infringement for other people to reproduce that design. The idea is if you want protection for that design for your chair, you should file an application to register it as an industrial design. Both patents and designs are limited by term. Most countries provide a 20-year term of protection for patents and 15 years for designs. It's after that time, once a patent is expired, then anyone else is free to sort of make and use the invention, or likewise with the design. After the design rights have expired, they're typically subject to sort of trademark considerations. Usually, people are able to use and make that same product. The other big difference on sort of the overall scheme of things is just the level of scrutiny that your application will receive from the Canadian Intellectual Property Office or USPTO, or in Europe is similar. So when you file a patent application, you need to have a detailed description of how your invention works and claim specifically what makes it different. And a patent examiner, who's someone with a science or engineering degree, will delve into exactly what you're claiming and with fine-tooth comb go over what's out there already and how is this really different. In addition to all the formal requirements of making sure your drawings are the right quality and you've got sort of clear language in your claims, but it's quite an involved process. It is common for it to take 2 years would be a sort of relatively quick prosecution of a patent application. More often it will take 5 years if you're met with some resistance. Designs, on the other hand, are they're still examined. I'm not going to say that just sort of sail through, but the examination is primarily focused on the sort of internal factors of the application. Like, is this actually show the article clearly? Is it, are the features, is it clear what you're saying is your design? And so you can often go relatively quickly to a registered design within a year or two. The drawback, of course, is that in Canada, we've got a bit of a backlog, but that seems to be par for the course with Canadian Intellectual Property Office at the moment. In contrast, like a European design can be registered within a few months because they just have a more efficient system. Just to spend a couple minutes on, so we can go to the next slide, Peggy, on sort of filing considerations. So as I mentioned, each country has its own patent system or design system, as the case may be. There are commonalities in that what a company will typically do if they're looking to protect their new invention or new design in multiple jurisdictions is they'll start with an initial filing in country, be it Canada or US, and then within 12 months of that initial filing for patents, you can file corresponding applications in many countries around the world that are members of what's called the Paris Convention. And then you can get the benefit of, say, your Canadian filing date in China. So that why that's important is, I probably should have mentioned this at the outset, you want to keep your invention secret before you, until you, at least you file a patent application. If you've made a public disclosure of an invention before you file an application, most countries will never give you a patent in that case. Canada and the US give you a 12-month grace period to file your application. But most countries in the world, if you tell people about your invention, it's too late to file a patent application, even if you file the next day. So going back to Bob's example of that Samsung source code disclosure through the ChatGPT, I really hope there was nothing patentable in there, because that could have basically really hampered their rights to get protection for what might have been in there. So similarly, you file a new design application. You file it in Canada, you've got 6 months to claim priority from your Canadian filing in all these other countries around the world. Each country is a separate filing with separate costs. So as you might imagine, costs can ramp up quickly if you're looking at a lot of countries, especially if you're like an early stage technology or new product. You don't know exactly if it's going to take off. 12 months, 6 months may not be a lot of time to figure out, do we really have a market for this in all these, China or Japan or Brazil. So one thing that is Canada has for a long time been member of what's called the Patent Cooperation Treaty. And relatively recently, I guess it was maybe 5 years ago now, we joined what's called the Hague Convention. So these are international treaties that allow a single application to be filed covering a large portion of the sort of industrialized world. So in a PCT application for patents, that it can cover up to 157 countries. And the Hague is now up to 96 members of the Hague Convention on Design. So what that means, you file a single application for a Canadian applicant, you file it through the Canadian office, and then they communicate it to the International Bureau at the World IP Office. And that application acts as a placeholder to allow you to have sort of a longer period of time in which to decide, like, oh, do we want to get a Japanese patent? And then, instead of doing your Japanese filing at 12 months from your initial filing, you can extend that up to like 30 months from your initial filing, which is an extra time. The Hague is not quite the same as it when you file your Hague application at, say, a 6-month mark, claiming priority to your initial Canadian, for example. You do have to designate and pay your fees based on which countries you designate at that point. But still, it's a smoother path forward to getting sort of broad international protection. I was going to get a bit into, but I think we're getting close up to time. Just in terms of the some of the recent case law, Canada there's not a lot interesting happening in sort of Canadian case law. Not many. Oh, thanks. I just got a note. I've got a couple more minutes. So, one recent change in the legislation in Canada is up until last year, you did not have to. You had a set fee for your Canadian patent application, and you had a discount if you're a small entity. But your costs are sort of like, you've got a basic filing fee, request for exam fee. They're kind of agnostic as to what you're actually claiming in your application. A fairly significant change in Canadian patent laws. Now we have, like the US and many other countries, we have introduced excess claim fees. So your costs will increase for each claim that you include in your patent application that is more than the 20th claim. And that is in line with the US. The US, your basic filing in the US tells you up to 20 claims. And by claims, I mean these are the features that you're pointing to, or combinations of features generally, that you're pointing to as new, that sets your invention apart from what is already known. So this, under the previous regime, it was fairly common for applicants in the Canadian environment to file, maybe I've seen cases with over 100 claims, which is good for sort of broadening your protection. But it does mean you're usually dealing with longer examination times, a bit higher cost in terms of professional fees. But your filing fee was the same. Now, if you're going to file 100 claims, you're going to have a lot of excess claim, like government fees, to be paid as well. And that the idea is to try to sort of get in line with the rest of the world and streamline prosecution a bit. In terms of the actual design in Canada, we don't have a claim in a design application. It's basically protection is determined by what is shown in your drawings, and you have an optional descriptive statement. Whereas in the US design patent, we'll generally just have a single claim, the features of the article shown in the drawings. And you can sort of carve out what you're claiming by sort of showing pieces of your product in sort of broken lines or dashed lines, as opposed to in solid lines, which are the parts that you're actually claiming as new. But there's not like a laundry list of all the different features that you're trying to protect. The claim is just a single claim in a US design patent application, and your protection is really determined by your drawings. So I think what time are we at here? We should probably turn it back to Paniota and open up to the floor for questions, because we've only got about 5 minutes left.
Sure. And Richard, why don't you just stay on for a moment, because there is a question for you.
Okay.
And the question that we have is, and I know it's a question we get a lot of the time from clients regarding patents and designs, industrial designs. And it centers around, is it one or the other? Which one do I pick? And we know, as a general comment, we tell clients that, there are various forms of intellectual property protection available, and it's not one or the other. But can you talk a little bit about the decision on patents versus designs in terms of what you pick and how they overlap? Because oftentimes there is overlapping and complementary protection by all of these forms of IP.
Yeah, that's a great question. And it's certainly not a one or the other kind of decision with respect to patents and designs. If you're coming up with a new product, and it's quite likely that you're going to have aspects that are protectable potentially, at least assuming they're new and like they're inventive, you could get patent protection for how something works, but you can also at the same time get a design on the same article. And maybe, I don't know if this will work with the Zoom background. Here's a little Dentons branded pen that I have. You know, it's kind of an interesting design. There's these little rings there. You know, that portion, let's just say this was a completely new pen. No one's seen anything like this before. Oh, that's, you know, you could get protection for design, sort of like with this kind of ring design right at the end, with these sort of concentric or sort of evenly spaced sort of silver rings. And at the other end, you've got this little, looks like an eraser, but it's actually like a, so you don't put finger prints on your touch screen. It's a little touch screen thing. So if that was a new development, and at some point it was, and you could have theoretically got a utility patent, or what we just call a patent for, you know, a pen with, or more generally a writing utensil with a touchscreen interaction device at the other end. At the same time, you can get a protection for the way it looks, just like the sort of aesthetic features of it. But actually, this does sort of remind me of another point that is the real decision point when you've got some sort of new technology you're working on is do you want to file a patent application, or do you want to try to keep this as a trade secret? Trade secrets are sort of like, there's kind of creatures of contract. They're not something you apply for, but they can be valuable, certainly. And a part of the process for filing a patent application will involve publication of your application, at least for Canadian applications, mandatory publication at 18 months. In the US, you can, if you agree that you're only going to file your patent application in the United States only, you can request non-publication of that application. But you will still have if and when you get your patent granted, it will still be public, at which point, you know, any sort of secrecy surrounding what's in your application has disappeared. So that's really the sort of the key upfront decision point, is like, is this something that I want to seek a patent on, or do I want to just try to keep this secret? You know, and that's a whole other kind of discussion, because secrets are kind of like, they're valuable, but they're fragile. Like if people, once a secret is known, there's not much you can do about it. I mean, you can go after people who breached a contract, you know, but that's all you can do. You can't go after a third party that independently came up with the same secret sauce. Whereas a patent application, if you get a granted patent and you have claims covering that secret sauce, you can go after independent third parties that can do any copying. They just came at the same solution, and you're protected.
Thanks, Richard. So I know we're at time, and for the questions in the Q&A that came in, and we've run out of time to answer. We have noted those questions, and we'll reach out to you to respond to those questions after today's session. So thank you to our speakers, and thank you to our attendees. This was a full sort of, I'll say, 360 on all areas of IP, and hopefully you found it helpful and enjoyed our session. There will be a post-event email coming your way, including a copy of the presentation materials, and other materials will be shared in the coming, in approximately a week's time. So thanks again to everyone for attending, and happy World IP Day.